This video is in response to a message I received from Lewis about his faulty MacBook. Now, many of you that have watched my channel will know that I've had my own issues with Apple in the past, and Apple is no stranger to a lawsuit or two, with a judge previously finding that Apple knowingly sold defective laptops, Apple being successfully sued for defective MacBooks, and even was almost sued by me on one occasion. I will link my lengthy story about my experience, about how many times I had to go back about the same problem, which I only realised the extent of when I was making the video, because once a story gets so long you realise just how bad it was and how long you went back and forth. But ultimately, for many different reasons, MacBooks still remain the laptop of choice for many people and for many reasons. But in this case, Lewis was talking about a laptop that he had, which had several different faults with it that Apple initially replaced several internal components on, including the battery, I believe, from the message that he sent me. Only for later for the battery to develop further problems, and Apple now says that he has to pay for a replacement. Now, the components in question were replaced in 2021, albeit the laptop was purchased a couple of years before that. So Lewis's main question is, what happens really when those components are replaced and then fail not a couple of years later, and Apple simply refused to replace anything without payment? Well, this topic and many others like it fall into what I consider to be a huge chasm in the legal process, because in England and Wales we have a small claims limit, that is an amount of monetary damages beneath which you cannot claim for your legal costs. That amount at the moment for a pure monetary claim is £10,000. So for a claim not more than £10,000, you cannot claim back your fees for legal advice or representation in going to court. In short, you have to do it yourself, else risk losing all of the costs to pay your lawyer. There is a small avenue of reclaiming some of those costs, and as a barrister, I've been successful previously at achieving those costs for my clients. That is usually, however, limited to situations where the other party has behaved unreasonably, as the rules put it. Unreasonable behaviour, however, doesn't mean that they've just given you something that's of poor quality. Unreasonable behaviour usually means that they haven't complied with the litigation process, they've disobeyed orders, they haven't filed their evidence on time, and all of these kind of things. Or simply they don't show up for court. So in those situations you can sometimes, if the judge is persuaded, achieve at least some of your costs at the judge's discretion, because the court has ultimate discretion over costs when it comes to the trial. However, the gap that I'm talking about is, how do you know what you are entitled to? Therefore, how do you know how to sue these people? How do you know how to go about it? How do you know what the process is, what you're supposed to do, what you're not supposed to do? And what if they just ignore you? What do you do then? Now, all of these kind of things are quite daunting with respect to the majority of people, because going up against a huge company like Apple, or anybody else for that matter, is going to be quite difficult. But that's where my channel comes in. That's one of the reasons I created this channel during lockdown, because I had a little bit of extra time on my hands, and now I continue this channel crammed in between other work wherever I can, usually daily. So for that, I would really appreciate it if you subscribe to this channel, if you find any of it useful, because I realize that around 60% of you that watch this channel are not subscribed. Some of you say that you don't need to subscribe because you get the videos anyway, but please do that, because it does help my channel to grow and to help many more people. So what is it that you have to do in this situation? Well, first of all, you have to know whether or not you have any legal rights. Now, the Consumer Rights Act of 2015 does give you fairly solid rights in respect of things that you've purchased. Some people will believe that there's no contract because you didn't sign anything, but that's obviously not true. You don't need to sign something for it to be a valid contract. For example, you go into a store, you ask for something, you pay for it. That is a validly formed contract. It's a contract of sale, and it's the intention to form legal relations. If you enter that contract primarily as a consumer and the other party is a business, it is a consumer contract, and it's governed by the Consumer Rights Act 2015 and the Consumer Contract Regulations of 2013. This implies a whole ton of different rights and terms into that contract that you may not be aware of, although you will be aware of them if you watch my channel for any length of time and you subscribe, as I've asked you to do so, because then you'll receive the other videos, especially if you hit the bell icon. Some of those rights include that it's got to be of satisfactory quality, it's got to be fit for purpose, and it's got to be as described or matching a sample and all of those kind of things. So even down to the extent that you test out a laptop in the store, the one that you get should match the one that you've tested in store. And it should be as described, so it should do the things that it says it does on the tin, on the box. For example, if I had hair, I'd currently be pulling it out because I have a dispute with Virgin Media, because I'm paying for what is advertised as a 1 gig connection, which is an average of 1000 Mbps. And this morning, checking it, it took over 2 hours to upload a video. I'm getting just over 100. So 1/10 of what I'm really paying for. I contacted their website online chat support. It said, "We're too busy. Let's shunt you over to WhatsApp." So over to WhatsApp I go through all the options, and then it says, "We're too busy. We can't accept your request by now, but you'll find some help on the help pages." Which obviously there aren't help on the help pages because the status shows that it's perfectly fine. And I'm just left with no avenue to complain, only 1/10 of the service that I'm actually paying for. That's my experience. You've seen the screenshots on screen by now if I've remembered to put them on. So what is a person to do in this situation? Well, your only recourse is to write to them to formally put them on notice that you will sue them if they don't resolve the problem. And you'll be relying upon various bits of the Consumer Rights Act, the terms that are implied into that contract. And just as an aside, if there is a term within the contract of purchase that is contradictory to these terms within the Consumer Rights Act, or it's in any other way unfair, then if it's an unfair term, it's normally unenforceable, meaning it's a bit meaningless. So you can then tell them that you are going to sue them on the basis that this is not of satisfactory quality. How do we determine whether it's satisfactory quality or not? Well, the Consumer Rights Act is typically weighted in favour of the consumer, and terms are as well. So if a term is particularly confusing or potentially misleading or ambiguous, then it is rendered and interpreted in favour of the consumer as opposed to the trader. So if you've got, in this case with Lewis, we've got a battery which is advertised at I think 1,000 cycles, 1,000 charge cycles that it's been advertised at. The current measure is at just over 500 cycles, so roughly half of the battery's life. Now it will be a question of fact as to whether half of the advertised life of a battery is satisfactory quality. Now the court will have to make a finding of fact and a determination as to whether or not that battery stands up to satisfactory quality and fitness for purpose if Lewis here were to bring a claim. Now, of course, this is not formal legal advice because I haven't looked through all of the correspondence and everything else. This is just a generic explanation on what you might do in this situation. If it were me, as it was me some time ago, I would write to Apple and tell them this is why I might sue you. So this is precisely what I did in my case. I wrote to Apple and I said, this is why I might sue you. And if you don't respond within 14 days, I will sue you without further notice to you. That's called a pre-action protocol. I've done lots of videos on letters before claim and what steps to take before you issue a claim and so on, with a full draft particulars of claim. Just as a heads up, this is not ordinarily required at this early stage. But just to show them that I was serious, I drafted this particulars of claim and I sent them a copy of this draft particulars of claim just to say that this is the statement of my case. That's what a particulars of claim is. It's a statement of your case and a statement of the facts upon which you will rely in bringing the claim against them. And it was only when I was ringing them up and constantly harassing them over the phone to tell them that I really want this sorted out that ultimately they did sort it out. So I'll put a link to that full story in the description below. Go and check that out. But what do you do if you've done all of that, you've sent these letters, you might have even drafted your claim and sent them a draft of it, and they still don't respond? The only option you've got is to actually sue them. So you'll need to make sure that you've got the correct address, which took more than a smile, even for me to get. You'll hear all about that in my video linked below. But they really didn't want to give me the official legal address to send them formal legal correspondence. The reason this is important is if you imagine any kind of big company that's got 100 or 200 stores across the country, if you simply send your letter of claim to one of those branches, then the company's official representative will at some point in court, I can almost guarantee, say that they didn't have sight of it because it only went to one of the branches and it didn't come before someone that has any authority to respond to such a claim. On that basis, they might try to claim some costs against you, remembering that unreasonable behaviour can amount to a claim for costs. Which frankly, if that's upheld, I don't think is really fair, because as I said, how are you to know where you are to send this letter of claim? It ought to be good enough just to send it to any place that this company does business. But as I said, I can almost guarantee that they will make the argument that it only went to a branch and it should have come to head office. So my guidance to you is to find out the legal address for receiving documents if possible, or otherwise just the head office. And whilst the civil procedure rules don't require that it's sent recorded delivery, if you do send it recorded delivery, then you can prove that they've received it. This also opens up another idea that I've got for an app to capture data and evidence along with a claim, which I'm trying to come up with ideas for names for. If you come up with an idea to capture evidence in an app, ping me. I'd be interested to know what your ideas are. But broadly speaking, that's essentially what you would have to do. You would need to send them a letter beforehand explaining why you might sue them, and then if they fail to respond, your last resort is simply to sue them. Now, as I reiterate, this is not formal legal advice, and on the one hand, whilst I would always suggest that you get formal legal advice, that comes along with the caveat that if your claim is for not more than £10,000, you cannot claim those costs back. So that's why I think it's a huge gap in the legal system. The courts and the civil procedure rules ultimately leave it all on you to find out what to do, how to do it, file the claim, end up in court. And on many occasions, I've heard of solicitors acting for the company, warning the individual that they're going to claim costs against them within this claim, even though that's ordinarily not possible. The court retains discretion, of course, but 9 times out of 10, if the claim is on the small claims track, it is not going to attract legal costs, save of course for the issue fee and the hearing fees. But if anyone does want my opinion for what it's worth as to whether or not a battery is fit for purpose and of satisfactory quality, having gone through half of the advertised life cycles of that battery, subject to how it's been used and some diagnosis, I don't think that's at satisfactory quality. I think it should last at least 80% or more of the advertised life cycle of that battery. So I hope that's useful to you. Please do remember to like the video and subscribe. And as always, thank you for watching.